Let's talk about one of the biggest mistakes that I see people leaving marriages make in the context of family law matters here in Australia. We're talking about time limits. For people leaving a de facto relationship, they have 2 years from the date of separation to commence proceedings seeking orders for the alteration of property interests. So, for them, the time limit, the limitation period, begins at the date of separation. Now, for people leaving marriages, so for people who were or are married, the time limit, the limitation period begins from the date the divorce order takes effect. And that is a huge difference. Where I see so many people come unstuck is they separate, but they remain legally married for years. So if people stay legally married for years, either of them remain within time to make an application to court seeking orders to alter their property interest. So let's take a situation where people separated 10 years ago, but they remain legally married. Technically, they're both still within time to commence proceedings seeking orders to alter their property interests. Think about how different your financial situation could be 10 years after separation. And the other thing is, when we talk about the property pool, we're taking a look at the property, the assets, liabilities, financial resources that exist at the current time, not just at the time of separation. Another common mistake I see people make is they incorrectly think that we only look at the asset pool as at the date of separation, and they incorrectly think that anything that happens post-separation is not relevant. When we take a look at the property pool, we'll be taking a look at the assets, liabilities, and financial resources that exist at the current present time, not just at the time of separation. To stop your ex making a claim months or years after separation, consider formally resolving who gets what by way of a binding financial agreement or consent orders as soon as possible after separation.